Trivan Debi for the appellants, and my learned friends James Guthrie and Yvon Jean-Louis appear for the respondents.
We have considered how to deal with this procedurally, and our view, subject to any vociferous protests from the bar, is that we should hear the appeals in two distinct chunks, dealing first with the question of leave as of right and, if no leave as of right, whether special leave should be granted, and then, subject to the answer to those questions, with the substantive appeal. How you divide the available time between the two halves is, of course, going to be up to you. Yes. Okay. Well, I think that we should certainly finish the leave aspect well before the short adjournment, in order to leave time, if leave be granted, to deal with the other matters.
Yes.
So if you would cut your cloth according to that measure.
All right. I'll try my best. So, if I may, as your Lordship rightly pointed out, at page 221 of the manual, there are four distinct questions to be answered, and I will deal with three of those which form part of the first leg of my submission right now, and the fourth one, if need be, later on. So the first point is when we read paragraph 4 at page 221 of bundles.
221 being which document?
It is a statement of facts and issues.
Page 8 of the statement of facts.
Yes.
So the first issue we argued is the concept of whether the concept of civil proceedings includes proceedings for judicial review. Of course, one has...
But it's virtually conceded, is it not?
It is.
Yes.
It is.
So
But it is very fairly considered by my...
I don't think you need to spend very long on that one, then.
It's a slightly wider question as to whether they're civil proceedings for the purposes of Section 81(1)(b).
Right,
Yes.
but
they're civil proceedings as opposed to criminal proceedings.
Yes,
So-
well, you accept
Yes.
that if the value threshold is passed, there's no independent objection to leave on the ground that they aren't civil proceedings.
Not on that ground, no.
No.
All right. So it will curtail, obviously, my submission, because I was going to rely on the case of Sprints, which is at tab 32, but there is no need for me to go to this,
No, there isn't.
where the cases of Anat and Ramdin, tab 38 and 27, were addressed by the Supreme Court. So, Lords, the next question, when we look at the Constitution, which is tab 1, at page 277. So, Article 81, an appeal shall lie from decision of the Court of Appeal of the Supreme Court to the Judicial Committee as of right in the following cases, final decisions.
You can take it that we've read the basic document.
Right. So the points, first of all, is the finality of the judgment. So there again, my lords, there have been a number of cases which have been referred to by my learned friend in his written case, and we have, on the part of the appellant, relied on the case of NATU, MCB, Mauritius Commercial Bank, against NATU, which is in tab 36. And I will just refer your lordships. It is tab 36. 36, page 879. If your lordships have a look at page 880,
Pardon me.
reference is made to the case of Sartre Rex against Gosh, 1971, 1/865. There is no need for me to read through this quotation. But then the next paragraph, your lordships will see what is defined as a character of finality. And my submission to the court is, even when we look at the stand of the respondents, that is, my learned friend did very ably in his written case, referred to two types of approaches. One of them being the application approach and the other one being the order approach.
I'm not quite sure what the difference between the two approaches is on the facts of this case.
Yes, I'm coming to that. So the facts of
Are these cases all on the difference between a final decision and an interlocutory decision, Mr. Sertier?
this is the point which is made. Is it final or not? My submission...
If the question is whether it's final or interlocutory,
Yes.
then the answer may be one thing. But your case, presumably, is that this decision is the end of the road of these particular proceedings.
Indeed.
Yeah.
For me, it is the end of the road because there is nothing else I can do. And in fact, Your Lordships
It's not
will...
like striking out orders, for
No.
example, which may be the end of the road but are interlocutory in character. It is essentially the complete resolution of the public law dispute.
Yes.
Right, well, we'll hear Mr. Guthrie in due course,
Yes.
but I don't think you need
Yes,
to
but
say very
if I can just supplement what I've said, having a look at what was said in the case of PLS, it is in tab 20, page 6.
Page
651, more specifically at paragraph 24, at page 660.
664, did you say?
660. 660.
Yeah.
Now, if we look at this paragraph 24, if we read the first three lines, a refusal to grant leave to apply for judicial review is a final and terminating decision which precludes a party from having the merits of his case considered at a substantive hearing. This is the basis on which my submission to Lordships is that there is no other way for the appellant to go if there is such a decision. So my submission is that there is finality and it complies with the conditions necessary to appeal as of right under Section 81 of the Constitution. Now, of course, my Lord, the next question is the one of value, the 10,000 rupees, because in the cases which have been referred to by my friend, more specifically the two cases of Anat and the case of Ramzin, there is the issue of whether it concerns only the judicial process or the monetary aspect of it. And my submission to your Lordships is that the case of Sprints, which has been referred to earlier, is the one. It is, in fact, at tab 32.
22.
32.
And it is the judgment of the Court of Civil Appeal in Mauritius. And I think it is worth going through part of it. It concerned the registration of a mark, and at page 856, your Lordships will see that the substantive paragraph, the main thrust of the objection of learned counsel for respondent number 1, whose observations were adopted by counsel for respondent number 2, is that the application which concerns the registration of trademarks does not relate to civil proceedings heard by the Supreme Court, and that accordingly the judgment of Supreme Court is not appealable. Now, of course, it dealt with whether it was a civil case or not when we look at the Courts Act and whatnot. And then your Lordships will see that...
Well, it's the subsidiary point that's relevant for
Indeed.
purposes of your
Indeed.
analysis.
Then your Lordship will see at page 859, it deals with the issue, the monetary issue, and which has been picked up, in fact, this case has been picked up in another case, the case of Li Cheng Ling against Société Pyeongsan, 2012. It is tab 14.
Well, hang on. What are we extracting from page 859?
Lord, your Lordship will see the last paragraph, because the one but last paragraph concerns the two cases of Anat and Ramzin. And your Lordship will see the last paragraph. The present case is different in the sense that the matter of registration of a trademark is essentially a property right, the main purpose of which is that it should generate rupees and cents. We know that the applicants have announced that the matter in dispute is worth more than 10,000 rupees as remain unchallenged.
Yes.
Our case.
Well, it's not quite the same, is it? Because a trademark is a proprietary right.
Indeed.
Whereas a license to operate a gaming establishment is not necessarily a proprietary right.
It is not. It is a right that we hold. And from the outset, my lords, you will see that it was stated
It's a
much...
condition of lawfully carrying on business.
Yes.
But it's not itself an item of property.
It is not an item of property, agreed. But your lordship will see that this monetary aspect was introduced from the early stages of the dispute. Mm-hmm. That is, even before the case was heard by the GRA, that is the respondent, there was this issue of investment of 20 million rupees. And this is why I made reference to this case of Li Chengqing, which concerns, it is not a judicial review, but it concerns rent, which is...
Yeah, but I mean, the question whether you register a proprietary right is essentially an adjudication on whether that proprietary right exists. It's totally different, I thought, from the context.
If we go along the line of thought of their lordships when they decided ANAT, which is a severance allowance case, my submission to your lordships is that the whole process includes a monetary value which has been introduced from the outset. It is not simply saying this is wrong. It is wrong because I was trading and the value of the whole aspect is more than 10,000 rupees. This is what I believe was the point which was introduced and debated in the case of Li Chengqing.
Right, you're about to refer us to that. You're about to refer us to
Indeed.
The case of Li Chang, are you?
Yes, it is tab 14, my lords.
Right.
And
You couldn't give us a page number, could you?
indeed, it's at page 15.
512. 51.
Thank you very much.
Yes. At page 519, paragraph 15, top of the page. The Judicial Committee,
I'm so sorry, which page are you on now?
519.
Thank you.
Paragraph 15.
Yeah.
Paragraph 15, the Judicial Committee did not give reasons for its decision to give special leave, but it is not its practice to do so. But it may be observed that it is not easy to understand why the Supreme Court thought that an appeal as of right did not lie in this case. It is true that the monthly rent of the premises is only 550 rupees, but the amount of the rent payable each month is not a true measure of the value to the appellant of being able to continue to trade in the premises. No figures were produced to indicate how much profit she derives from the business each year, but it is hard to believe that it is less than the relatively modest sum of 10,000 rupees per annum.
This wasn't a judicial review, was it?
It was not, my lord.
No.
It was not. I do agree that when I think my friend made a certain comments concerning the 10,000 rupees. 10,000 rupees today is not much. Bounce it's not very much.
No.
But even so, there is a threshold which is 10,000 rupees, and I do think then we look at the case in its entirety, that whether it is civil proceedings, it is final, and there is a connotation of value which is more than 10,000.
Well, looking at the value point, this was essentially a dispute
Then
as to the the interests of the parties in,
Yes.
in a real property.
Indeed.
So, again, it appears to fall squarely within the provision of the Constitution.
Indeed.
It doesn't raise the questions which the present case raises.
Yes. Now, when we look at the Constitution, when we look at tab 1, where the matter in dispute of the appeal to the Judicial Committee is of the value of 10,000 rupees or upward, or where the appeal involves directly or indirectly a claim to, or a question respecting property or a right of value of 10,000 rupees, it is very wide.
Well, the point that you've got to deal with, I think, is the authorities which indicates that that in judicial review cases, the subject matter is the propriety of the decision rather than the financial consequences of the decision.
Yes.
I mean, that seems to me to be the burden of the other side's case, which you have to address.
Of course, yes. I think that the basis of the case itself is about the review of what took place before the restaurant.
Yes.
And I don't want to go into this, but this is the remedy which is sought is against this review. And attached to this review is this financial component. So my submission that I really feel that it covers the whole spectrum, that the case of the appellant falls squarely within the spectrum of 81(1)(e), because the first issue has been accepted, but the other corollary issues, my submission is that they are to be included. So this will be, and one of their lordships did make some remark concerning this monetary aspect, the 10,000 rupees. If you may care, my lords, at page 157 of the proceedings.
Which document is that in?
It is the proceedings before the court. In fact, the proceedings before the court on the 8th of February 2017.
Okay, I've got that.
Bottom of the page, Mr. Balancy, His Lordship, Mr. Balancy. We have no problem with the figure of 10,000 rupees. Please understand that. We have no problem with that. I mean, we can see that the business is about. Any rate, financial statements have been put in. So the mere aspect, the financial aspect, I don't think it's in dispute or disputed by the court. So
Well, I don't think you can really rely on an interlocutory observation in the course of argument. We're really concerned with the judgment.
yes, yes.
On which they...
The judgment, my lord, it goes squarely on the decisions of the Supreme Court in the case of Anat and the other cases which I mentioned. And my submission is that we should not draw a line, a definite line between what was the main purpose of the applicant when it was the Supreme Court and not to encompass everything. So that is my submission to your lordships as far as the direct under section 81(1). Now, there is another issue which has been raised, which has to be answered when we look at the statement of facts and issues, is at page 221, is assuming that the board answers the questions in paragraph 1 affirmatively, the principle that where leave to appeal as of right has been wrongly refused by the court below, the judicial committee will, save in exceptional cases, grant leave will apply. My lords, I must turn to my friend because he did rely on a case, in his written case, which is of extreme relevance to the point before the lordships, and it is at page 267 of the room. You see that Manuel Federal reference.
which document is that?
It is in the written case of the respondent. And the case, if I could produce twice the written case.
The recent Guernsey case, is this? Right.
It is the case of
This is Crawford and Financial Services.
No.
A and R.
It's A and R.
that runs in 2018.
That case simply applied to Crawford and Financial Services institutions.
So this is in tab 3. We've got it tab 3 in the that page 377.
Yeah.
The relevant parts of what I was going to submit to the lordships needs to be found at page 382, paragraphs 11 and 12.
This is the case where there is an appeal as of right, but by mistake, the court below has not recognised that.
Yes.
Fact. Yes?
Yes.
Right.
Now, my lord, there again, I would think that...
I mean, the principle stated in the authorities is that you can have an appeal, you could be entitled to appeal as of right, but your appeal will not be received if it's hopeless.
Yes, indeed.
That's essentially what it is.
Yes, yes.
Right?
If the case is hopeless, yes.
So you
And-
submit this isn't hopeless?
No.
Right.
As simple
Well,
as.
I mean, in due course, you're presumably going to address us on the question whether we should grant special leave if leave is not required, which is, so if special leave is required, so you can deal with that, the question of arguability under that head, can't you? It applies at both levels.
My submission to your lordships is that if I do not succeed as of right, that unless my case is absolutely hopeless, that your lordships
Yes.
under section 81.5,
Yes.
this would be like my stand.
Well, that would be a submission that you are entitled to special leave in every case where you have some sort of argument.
Yes.
All right. Well, maybe.
Well, in every case which satisfies the other conditions on which you've already addressed us.
No, he's on.
No, but this, for me, it is,
You're now
it
on
is
special.
plan B.
Well, you are now addressing us on special leave on the footing that you are not entitled to have leave as
No, I would say if your lordships, because I think there are three stages. The first one is if I'm entitled as of right, then obviously this second...
Secondly, is this a case where we should effectively strike it out, although you're entitled as of right, because it's
section
hopeless? Thirdly, if you're not entitled as of right, ought you to have leave on the usual, more general criteria?
Yes, if I'm not entitled as of right. But then
You're now on point 2 of those three.
I'm on point 2 and 3, in fact.
Okay.
Because point 1 is as of right, and the second limb is section 81.5.
Yes. Well, I think if you can satisfy us that it's a proper case for granting special leave, by definition, you will also have satisfied us that it's not hopeless.
Yes, Lord, but it not entail my submission on the substantive part of the case.
Yes.
Which I'm ready, of course, but
Well, I'm certainly not going to invite you on a leave application to make all the submissions that you would make on the substantive appeal. But I think it would help if you were briefly to summarise on what ground you consider and submit that the case is a proper one,
Yes.
assuming that special leave is required.
my submission is that when we look at the written case for the appellant, is that the principles of fairness, the basic principles of fair hearing are not been adhered to by the respondent, and that the cases which have been cited, without going at all into the merits of each of the case or the decisions, they show that we were denied the opportunity.
Well, the ground given by the Court of Appeal was that effectively that the police opinion was conclusive.
Yes.
Now, if that's correct, then the fairness issue hardly arises.
Yes. I would say it is not.
I understand.
I would say it is not, because one cannot merely rely on the opinion. If we go into details of a letter which was first sent on the 18th of October 2009, just without granting the opportunity to the appellant before the board to take cognizance of same, and also to remark that.
Well, you were told, weren't you, that the police objected on the grounds that there'd been a number of disorderly incidents.
Yes, I will address that fully.
Yes, but I mean, we're concerned with now is whether whether it's arguable that was something that the board or yourselves were entitled to challenge.
Well, the police has the right, to put it simple, the police has got the right under the law to cancel or not to grant under Section 96 or to cancel if there are problems.
Right, to not to grant.
Yes, 96.
You accept that in that context, the opinion of the police commissioner is conclusive.
I would accept that it is the basis of any action against any person. And
Well, it's a condition of the right
absolutely.
to get a grant of the license in the first place.
These assertions have to hold water. This is what I'm going to say. Because at the end of the day, my lords, we should not forget that the premises where the appellant was trading was opposite the police station. Opposite the police station. And for 6 years, there has been absolutely no complaint. We should not forget that every year this license has been renewed with the concurrence of the Commissioner of Police and all other authorities. So there has been no complaint whatsoever over the past 6 years.
But I mean, are you asking us to say that the police commissioner's opinion was perverse?
Fraud. Yes.
So fraud.
Fraud. Fraud.
Fraud.
It was. It's not. It
But it was wrong.
It was never substantiated. It is an opinion which was not tested. At the end of the day, we say we have the right to know because there are. I'm going a little bit in my submissions. There are two documents. Actually, one at the.
Well, at this stage, we're simply working out whether this is arguable.
Yes, I say that the opinion of the Commissioner of Police was never tested, and we were not given the opportunity to test this opinion. And this goes in all the judgments which have been referred to do spell out that they had to give us this opportunity.
Can I take you back a stage
Yes, my lord.
before that, Mr. Serzier? Do you agree or do you not agree that, assuming it was not perversely or utterly unreasonably arrived at, the police decision is conclusive of whether your license should be revoked or not? Now, is it or not?
I would think that the police, it cannot be conclusive because if it is conclusive, I would say that it is the basis of renewal or extending.
Does it follow from that, if you're right, that there is a difference between the original grant,
Yes.
which is governed by 96.4,
Oh, yes.
and a revocation, which is 96.9K? Now,
99.
why is there a difference between those two?
That is, it has been argued that the word may or shall.
It's because of May, I see.
Because when there is a license which is granted, there is an imperative on the Commissioner of Police, whereas 99.1K, the word may is written. So
I think we understand the argument that you want leave to run.
Right.
Well, I'm grateful to you. Thank you, Mr. Guthrie.
My Lord, in relation to the civil point, as you know, we more or less conceded. I should say, though, our position is, I think, summarized in paragraph 8 of our case. We submit that it wouldn't be correct to suppose that the courts in Mauritius, in fact, refused leave to appeal, either in this case or in the various other cases which have been referred to, on the simple basis that judicial review proceedings are not civil proceedings. It does look from the language sometimes as though they're drawing a false distinction. But if one goes into the meat of the judgment, in fact, what they're saying is that leave is not available as of right, either because the matter in dispute is not a matter properly considered by reference to the prescribed financial value, which is ordinarily the case in judicial review proceedings, because the subject matter of the dispute is the propriety of the decision, or because the appeal doesn't involve directly or indirectly a claim to or a question respecting property or right or others. And if one looks carefully at the various decisions, it can be seen, we submit, that the courts haven't simply drawn a blind distinction between civil and administrative proceedings. Lords, in order, I hoped to save time at the hearing, I did set out in my written case chapter and verse about all this, and I think it might be wearisome if I were to do that orally as well.
We're not inviting you simply to repeat what you've already said in writing.
Well, I hope that I can effectively leave it at that.
Yes.
The court shouldn't be criticised for too simplistic an approach.
No, but anyway, effectively we have got to decide this for ourselves, whether the court below expressed it in the right or the wrong way.
Our main point, Your Lordship has already adverted to, in the ordinary judicial review case, decided is not a right to property or a claim to a sum over or upwards of the prescribed value. It's the propriety of the decision, and that's why the courts reached the right conclusion.
Yes.
Well, there is one case which I've referred to, which it might be helpful to look at, which shows that in a judicial review case, which includes a claim to a sum of money in excess of the value, the court will grant leave. It's the case of MSCL, which is in the bundle referred to in paragraph 21 of my written case, and you will find in the bundle of authorities at page 884. Lords, I don't want to go into the facts in too much detail because, in fact, it's a case in which leave was granted as of right, but your lordships have yet to hear. But on the question of leave, you will see at page 886, they refer to the judicial review cases, including, in fact, this case, Jacpot, and they say they agree with the reasoning of the court, no intention of departing from the well-established principle that no appeal will lie to the judicial committee under section 81 subsection 1b, where the challenge is only with regard to the decision-making process of a statutory body or public institution in the course of judicial review proceedings. They then go on to say that in this particular case, it's different because the decision of the tribunal which was being attacked also included an award ordering the applicant to pay severance allowance, a sum calculated to exceed 20 million rupees. So one sees that the court is alive to the distinction.
Yep.
And my lord, that's what we say the position should be.
Understood.
But that deals with the subject matter of the dispute point,
Right.
which is developed a little more.
And
in
there's
my
the
case.
finality.
There's the finality point. My
What
lord,
do you say is the difference?
entirely, I
between
understand exactly why your lordship said what you did in the course of my learned friend's submissions. Unfortunately, the finality point has given rise to all sorts of difficulties in the past. And although your lordship said, of course, this isn't a final as opposed to interlocutory situation. In fact, the test for the grant of leave as of right has been approached in the same way in the past, including by the Judicial Committee.
As the question of final versus interlocutory.
Yes, it has. There's one case which is in the bundle.
Are you suggesting that this particular decision was interlocutory? It was a determination of the proceeding?
If the test is being applied as to either the application or the order approach, yes. But one can see the Privy Council looking at it in this way in a case which I've included at divider 35 of the bundle, page 874. And perhaps I can preface it by saying that it appears that the board is content to follow the the process according to the local practice. This was a decision from the Supreme Court of Victoria, 1973, and the head note, leave was refused by the court in Victoria. The head note at the top of page 876. It was submitted, and their lordships would be inclined to agree. It's not the head note, I'm sorry, it's Lord Kilbrandon's judgment. Their lordships would be inclined to agree that the authorities are not in an altogether satisfactory state. There is a continuing controversy whether the broad test of finality in a judgment depends on the effect of the order made, as decided in Boson and Altrincham by Lord Ulverston, or on the application being of such a character that whatever order had been made thereon must finally have disposed of the matter in dispute. Salomon and
The
Warner.
difference between these two tests only matters, surely, when you've got a decision which is interlocutory in form but closes the door, e.g. a striking out application.
Well, I think in this particular case was, yes, of that sort, yes.
But I mean, what I don't follow is why is this decision not final, even on the applications basis?
Well, Lord, I can only say that in the past, that seems to have been the test which has been applied as to whether final is one sort of case, interlocutory is another sort of case, and there's nothing else.
But why isn't this case final on both tests?
Because
It both puts an end to the relevant procedure.
because if the application had
Disposes of them.
if the application had succeeded, it would have been remitted back to the board.
Yes, but the decision that was challenged would be destroyed and it would be remitted back for a fresh decision.
Well, my lord, I don't want to stand here and really fight the other corner, because it seems to me, with respect, that it's perfectly reasonable to look at it in that way. And indeed, I have, I hope fairly, cited the authorities in my written case, which appear to support what your lordship are putting to me now, because I think, where have I, I mean, it's no part, I think, of my instructions to hold out for interlocutory as opposed to final. But certainly, I think in paragraphs 29, well, your lordship should perhaps know that in Trinidad, the final interlocutory test is applied in all these cases. But I set out in paragraphs 29, 30, and cases from the Lordship's Board where it said that the matter has been finally disposed of and no appeals been admitted.
Yeah.
So I'm not going to.
What do you say about special leave, assuming that special
Well,
leave
can I just? I think perhaps I think probably the question of whether, if final leave should have been granted, what the test should be. My learned friend showed you A and R.
Mm-hmm.
I think that does provide the answer. But I did want just to advert to something which is mentioned in my case. It seems to be a slightly different test than the one which is set out in the practice.
Well, the A and R is about the test for effectively striking out an appeal as of right, whereas the point that I think we're on now is whether, assuming that there isn't an appeal as of right, and therefore the question is whether we grant special leave, what you say about whether we should grant special leave or not.
I think Mr. Guthrie was wanting to say something about A&R before you got on to that point.
Well, all I really wanted to do was to say that it seems to the respondent, at least to me, that A&R, if you like, if there is a distinction between A&R and the practice direction, that the practice direction now has to be read in the light of A&R,
Yes.
and possibly puts the test a bit too high, because it refers to a reasonable prospect of success rather than absolutely hopeless.
Yes,
But that's obviously
that sounds right.
a summary of it. I mean, on the question of whether special leave is justified, in our respect for submission, if the matter had come before your lordships in the ordinary way on a, so to speak, paper application for special leave would have been unlikely to be granted. Well, I don't know to what detail I ought to go so far as
Well,
answer.
under the old-style oral applications rule in the House of Lords, you had 10 minutes aside. Shall we proceed on that basis?
Yes, certainly. Well,
That's a question.
I'll certainly try and do that. If one looks at the provisions of the Act, one has an absolute prohibition on granting a licence where the opinion of the Commissioner is that the premises are not satisfactory. Now, it's not just a negative opinion that they're not unsatisfactory. He has to give a positive opinion that they are suitable. And obviously his remit relates to public order and so forth. Section 99(1) of the Act, which is dealing with disciplinary licensees, is a compendious section which deals with a number of possibilities. Your Lordships will find it, I think. It's at about 287, I think. I'm sorry, no, 328, sorry. And you will see it provides for a number of possibilities under Section 99(1). The only discretion seems to be between the refusal to renew, on the one hand, or the suspension, or the revocation, or the cancellation of the license, or the determination of the license. Obviously, in relation to certain of the subsections, may is an enabling section which doesn't really import any discretion at all. One can't imagine how the board, for example, could properly exercise a discretion to not to do one of those things where the licensee has become disqualified for holding a license, for example, or the minister has directed in the public interest. And we say that the same applies to K.
You could presumably apply for judicial review of the minister's objection.
Yes.
What about A, Mr. Guthrie? False.
Well, in certain respects,
False statement. I mean, is the board in a position to say this particular form received an inaccurate, i.e. false answer, but frankly it's trivial and we decline to revoke on that ground?
well,
I mean, I understand the point about disqualification, of course.
yes,
I do.
no, it may very well be that the way may is used in all these things and has to be construed in a slightly different way in relation to the various different different things. I mean, I certainly accept that if it has to be a falsity in a material respect, but it may be that there's more room for discretion in relation to some of these than others, but
Yes,
there
I mean,
can't be any room for discretion.
B, shoplifting by a shareholder, for example.
Yes, but I mean, but there can't really be any room for discretion in P or L, and we would say not in relation to K either, bearing in mind that you have to read K, having already read Section 96(4). So that's really what our point is in relation to that. Yeah. If the section does apply, there isn't any room for the gambling regulatory authority to do anything other than one of the things under subsection 1. It can't impose a financial penalty, for example. It can only do that under Section 99, subsection 9, where there's been a miss. I think it's
Conditions, isn't it?
Yes, there's been some condition of the license has not been complied with. So, and there's no provision in the Act for the regulatory authority, so to speak, to second guess the Commissioner's opinion. What happened in this case was that, as I think my Lord observed, the appellant was given full information or sufficient information that there had been an objection. At that stage, they didn't ask for further better particulars of it. they did write a letter and asked for a hearing. There was a hearing at which they were represented by counsel, and there isn't any complaint, I think, that that hearing was conducted unfairly. What did happen, we know from the judgment, was that the board, having been asked, having had a submission made to it that there was insufficient particulars, went back to the Commissioner of Police and found that indeed the objection by the Commissioner was being maintained. In that case, the board, having confirmed that the objection was a genuine one, really was in no position to do anything other than revoke the license. So, in our respect to submission, the Supreme Court was right about it.
Thank you. Mr. Sozier. Right. We will rise for a few minutes to consider the leave application and return as soon as may be. The board have considered the leave application. They consider that this is a case where special leave is required, and they do not propose to grant special leave. They will give their reasons on both points in a judgment to be handed down in due course.
Apply for the respondent's costs.
That's all right.
Very well.